get started in just a moment. Please close the back door. Thank you. The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning. I will begin with just a couple of small logistical notes. One, very importantly, I want to express our appreciation and gratitude to Judge Garcia of the District of New Mexico for sitting with us today. I hope the New Mexico judges aren't going to gang up on me and that I can survive that. The second note is after the Stoneberger versus BP Energy Company case, we'll just take a very brief break for about 10 minutes and then come back. With that note, we'll hear the first case this morning, which is 24-3169. I know I'll mess this up. Stimatze versus Board of Commissioners of Geary County, Kansas. I'm sure Counsel for Appellant can correct me. Please.
Good morning, Your Honors. My name is Chloe Davis, and I'm here on behalf of Appellant Michelle Stimatze versus the County of Geary County, Kansas. May it please the Court, Your Honors. This appeal arises out of Ms. Stimatze's employment as the Director of the County of Geary County's Visitors Bureau for the Board of County Commissioners of Geary County, Kansas. Ms. Stimatze began serving in this role in 2017, and she remained in this role until her constructive discharge in June of 2021. Between 2017 and 2021, Ms. Stimatze received favorable employment feedback from the county. Her work product was described as good and excellent. However, in 2021, when a new commissioner was elected to the board, Ms. Stimatze began to notice concerning behavior. For example, Commissioner Giordano, which was the newly elected commissioner, requested that Ms. Stimatze allocate government funds to certain line items without proper board approval, which was outside of county policy. Commissioner Stimatze also refused to allocate necessary funding to the Visitors Bureau, which was also outside of county policy.
Ms. Davis, if I may jump right in. In rejecting the retaliation claim, the district court cited our decision in Leverington. And in that case, a certain language sticks out to me, which says that essentially what actually the crux of the matter, and I think Leverington used that word, in a public concern inquiry is what is actually said. Well, it gives me some pause when I look at the amended complaint, that the amended complaint never says what your client said. It speaks in generalities about what she talked about in terms of subjects and topics, but doesn't use the language of what she said, which if you look at a number of our cases, they in fact say, I said X, Y, and Z at X setting. Why isn't that a problem for you?
Yes, Your Honor, and I do believe that that is the crux of what's before the court today, is essentially the proper pleading standard. I will agree, Your Honors, that the amended complaint does not contain the exact words of what Ms. Stimatze said at the meetings and her speech. In Leverington, I do believe, however, that they were, they had the exact language of what Ms. Leverington said to the police officer, and they were able to determine based on her speech that it was her speaking to personnel issues or a personal issue with the officer that was involved. I would also point out, however, Your Honor, that this court does have decisions where the exact speech was not analyzed, and the court was able to analyze the speech based off of topics and categories, which is reflected in the Garcia case. The court yet determined in Garcia that the speech was related to personnel matters or personal grievances in the workplace. However, they were able to still analyze the topics or categories of the speech as opposed to having the actual speech. Your Honors, our main argument here today in relationship to the amended complaint not including the exact language would be that Ashcroft doesn't require that. It requires a pleading standard where there's enough factual information to state a plausible claim for relief. And here we believe that requiring the pleading to contain the exact language of what was stated would be beyond that threshold or that standard.
Well,
Go ahead.
well, on paragraph 32, and I'm going to be referencing your amended complaint, on paragraph 32, it seems to me at least one thing that gives me some pause, I'm not saying it's definitive, but one thing that gives me some pause is that even if you get out of the realm of language, one has to sort of piece together exactly what it is that is alleged to be problematic of concern, of public concern in the speech. For example, in paragraph 32, it says that plaintiff raised concerns about, quote, spending allocations. But that doesn't tell us what those concerns were. It doesn't tell us how those concerns relate to other paragraphs in the complaint. And so, I mean, you're making us work here in a way that I'm not sure that Iqbal does require. I mean, for example, you go to paragraph 17, and it speaks about allocations related to the Convention and Visitors Bureau. Are you saying that that's a matter of public concern?
Your Honor, I think the distinction here would be that it was Commissioner Giordano's interference with the allocations to the Visitors Bureau. And looking back at the language of paragraph 32, I should have included references, for example, the speech referenced in paragraph 17, 18, and 19, because those are the concerns that Ms. Stimatze spoke out about. both the interference with the allocation issues themselves being outside of county policy, and then the allocation to certain line items, which were also outside of county policy.
So 17, 18, and 19, as it relates to, the Giordano doing things that are against county policy, let me just put that in one category for a second. I mean, the idea that he wouldn't approve defendants, he wouldn't approve allocations related to the Convention and Visitors Bureau. Why doesn't that just put us in the zone of that's a personnel problem? I mean, that's her purview, right? And he wouldn't give her the money she wanted to do her job in that position. What is a public concern about that? Why do I care about that?
Sure, thank you, Your Honor. So I think that Commissioner Giordano refusing to allocate proper funding to the Visitors Bureau would fall beyond a personnel grievance issue because it does impact the community at large. They are dealing with tax dollars, and properly funding certain departments would be, I think, an issue that would go beyond any personnel grievances between Ms. Stimatze and Commissioner Giordano.
Let's try Garcetti, in which you had, I think, at the heart of a public concern, a prosecutor and decisions that a prosecutor makes about the liberty of individuals. Well, the Supreme Court said that was a personnel problem, right? That's your personal problem. And so if that is a personnel problem, why would I care about the Convention and Visitors Bureau if the Supreme Court didn't care about that public issue in Garcetti? And well, it wasn't a public issue, the issue about the prosecutor there.
Yes, Your Honor, I think here there would not be a large difference in the analysis there. However, I think I would just revert to the answer about the fact that the refusal to allocate necessary funding does impact the community at large and not just Ms. Stimatze. So it's not, so in Garcetti, it impacted one person's freedom of speech who was the plaintiff appellant. Here, refusal to properly allocate funding would impact the community at large.
Let's focus for a second on paragraph 16, and in particular, the line that says Defendant Giordano would request that plaintiff allocate funds to certain line items that were essentially against county policy. Give me your best argument as to why that is a matter of public concern and what you would identify as probably the lead case that I should look to. Is it Garcia or some other case in determining that I should view that as a matter of public concern?
Your Honor, so there are several cases actually that indicate that public officials doing things that are outside of that public entity's policies are considered matters of public concern because it shows the public official's impropriety or unethical behavior.
And I apologize, you initially listed 17, 18, and 19. Don't you believe that isn't that within the zone of what you're concerned about too?
Yes, Your Honor, I would also include 16. I apologize.
Okay. Okay, please go on.
Okay. So I won't go back to where I was at in my outline just because we've already discussed it, but I will just reiterate here, Your Honor, that, Your Honors, that the applicable standard is the Ashcroft-Iqbal standard and not some other heightened pleading standard. And we would argue that Judge Melgren's decision would demand a higher pleading standard based on the fact
Counsel,
that—
can I ask you, weren't you counsel in the Von Busch case?
I was.
Okay, how do you distinguish that case from this one?
So first, Your Honor, I will clarify that in the Von Busch case, they were analyzing a different prong of the Garcetti-Pickering test.
But it was the same problem.
It was
Same
this—
defendants, same problem in the complaint.
Yes, Your Honor, it was the same pleading standard issue. And the point I believe that that case hinged on was the court could not determine whether or not the speech related to Ms. Von Busch's official duties because the complaint did not include any description of those official duties. While that would apply here, it would be our position that was not an issue at the lower court. Judge Melgren didn't reach that analysis. He found that that Ms. Stimatze was speaking as a private citizen and that she was not speaking to not speaking to her official duties.
But another panel from this court determined that the complaint in that case also did not meet the requisite pleading standards. And I guess I'm just trying to figure out whether it's the same defendants, the complaint similar. Granted, it was a different prong, but ultimately it all comes down to the same issue, not enough facts to substantiate the different elements that you're required to meet. So I'm just trying to figure out what is the difference fundamentally as a substantive matter.
As a substantive matter, Your Honor, the pleading standard, there would be no difference. We would argue the same thing that we argued on that case, that Ashcroft standard does not require the specific speech to be included in the complaint. So as a substantive matter in terms of pleading standard, what the court determined in Von Busch would also apply here.
So I like to think of myself as a pragmatist. Why not just add 2, 3 more paragraphs in the complaint? You could have solved both of these problems in both of these cases, it seems to me.
Yes, Your Honor. Several years later, I do wish that I could go back and do that. It would have made things much easier. Not that I wouldn't want to be here today,
Oh, yes.
but
Oh, when I was on that side of the bench, I loved it. Yeah.
yeah. So if that were a path still available, I would have taken it.
Were alerted to it by their motion
I was,
and didn't respond. If this had been a pro se complaint, I think a lot of the magistrate judges would say, you need to tighten up your complaint. You need to add some stuff. That's for pro ses, and the pro se would put what facts were available. Here we have counsel, and we don't need to help you in those ways. You have a responsibility. So why not respond to the motion?
yes, Your Honor. So you mean the initial, so the complaint was
File
all,
the complaint, there's a motion to dismiss on this ground, and the easiest way to respond would be to request an opportunity to amend the complaint.
yes, Your Honor. To answer your question directly, I was approximately 1 year out of law school at this time. That's not an excuse. Then, which leads me back to my answer that looking back, I should have done that. What I will say here is that looking back at my analysis at that point in time, I did believe that what I had included, which was that Ms. Stimatze spoke out about Commissioner Giordano's improper funding allocation, what I described in the complaint. I did feel at that point in time, and I still do, that it satisfies the Ashcroft-Iqbal standard.
Counsel, let me ask you this, though. You said that the duties component, number 1 on Garcetti, is not at issue. Well, your opposing counsel is putting that forward as an alternative grounds for affirmance. So it is before us, right?
Yes, Your Honor. And to that point, first, I would request that the court opt not to exercise the discretion and instead of remand. However, and I would like to reserve at least 1 minute, but I do want to finish my answer to your question.
Please do.
We would argue that these statements were made at public forum meetings to other members of the public and not in any way pursuant to her official duties. And I think that there are several cases that indicate that because the statements were made at events that were outside of her duties, she was not at any type of Visitors Bureau event sponsored by the Visitors Bureau, full of Visitors Bureau personnel, that this would fall outside of her official duties. She was not the commissioner's supervisor. She had no duty to report this behavior on the part of the commissioner. So we would argue that it does fall outside of her official duties.
You'll get your minute. Let me ask you this question. I take it count 2 is not at issue here, right?
Correct.
Okay, thanks.
May it please the court. Patrick Linden on behalf of the Board of County Commissioners for Geary County, Kansas. The present appeal turns upon the question of what is necessary for a former government official to allege a plausible claim that she engaged in speech protected by the First Amendment as part of pleading an employment retaliation claim under 42 U.S.C. Section 1983. And here we're talking about the first two prongs of a five-prong test. It is not enough to merely allege that one engaged in protected speech to survive a motion to dismiss. Rather, there must be sufficient fact information in a plaintiff's pleadings to demonstrate, one, that the speech was not made as part of the former official's duties, or two, that it involved matters of public concern. Here, the district court dismissed plaintiff's claims, finding that the plaintiff's amended pleadings lacked sufficient information to plausibly allege that she had engaged in protected speech regarding matters of public concern. While that decision was correct, it is Appellee's position that based upon the applicable cases and the conclusory allegations of the pleadings, that there is also an alternative basis, to affirm the dismissal of plaintiff's claims in this matter.
Well, let me start with public concern. At least as I read your brief, it suggested that she needed to plead, counsel needed to plead specific quotations in her complaint to provide the sufficient facts to support a public concern argument. Is that your position?
Quotations would certainly be most likely to get you over the threshold. I think you need factual information, not just a conclusory statement of public concern.
Well, she does more than, this amended complaint does more than say the plaintiff spoke on matters of public concern. She identifies topics, as she pointed out, that the plaintiff spoke on, does she not?
She does include topics. However, there is not enough about the context of those topics, the form of discussion, to really get an understanding of whether those issues rose to a level of public concern.
Let's try
because
this.
there's a
Let's try
continuity
this.
there.
In footnote 4 of a case called Morris, which is one of our cases, you have, our court said this, quote, a narrow range of speech where the subject matter is clearly identified, that there's a narrow range of speech where the subject matter is clearly of public import. And that narrow range of speech included the area of corruption. Why isn't it enough then? And to be clear, what the court was saying that is if you identify certain topics, they are invariably of public concern, and therefore they should be matters that, within the scope of the legal test would be sufficient. Well, why isn't it enough that plaintiff here pled that defendant Giordano was doing things that were against county policy? Why doesn't that sniff of corruption? And why, therefore, wouldn't it be enough to say that to let you know that the public in that county really cares about him violating county policy?
I would respond that irregularities or deviations from public policy do not equate corruption per se. And therefore, you need more.
I hear you.
than what we
I
have
hear
here.
you saying that, but why is that necessarily the case? If we're construing the well-pled facts and the like most favorable to the plaintiff, if the plaintiff says that he was violating county policy, well, it would have been lovely if there were more facts in there. But why isn't that a topic that the public would care about when it goes to allegation of dollars, mind you, and public dollars?
Yeah, I think it's a matter of the significance of the issue. I mean, as I think it was discussed during Appellant's opening argument, that there are a range of these issues. Not every deviation from a county's policy rises to a level of public concern. It could be simply an issue of minimal importance. And we need more in the pleadings to know whether it crosses that line. Otherwise, every minor tick-tacky variation from county policy suddenly becomes the basis for a potential Section 1983 claim. I think there needs to be some articulation of what the issue of public concern was, and to give the court, the district court in this instance, enough information to understand that, yes, this rose to a level where it was a matter of public concern, and not simply a matter of disagreement between two government officials about how county policy should be executed.
If there are government dollars at play and there is an intentional allocation of those dollars in a way that violates county policy, what is it that you think we should have that would allow us to determine that it is a matter of public concern? I mean, I get your point. I mean, I get your point that there's a point where it's essentially de minimis, but really what I'm trying to focus on is in the context of a motion to dismiss. I mean, you can win later. I mean, at a motion for summary judgment, why isn't that enough in a motion to dismiss to get you over the hurdle?
You know, in this instance, I think if we're talking about budgeting on line items, it might be, the criteria might be, what are the line items? Are we talking about a matter of a few dollars on the CVB's budget? Are we talking an item of $1,000 or $10,000 on the line item budget?
Isn't that what discovery is for?
Ultimately, discovery would reveal that, but here we are trying to at least determine if there is enough to pass the initial threshold. And
The
here,
initial threshold being plausible.
plausibility, that there is enough, that the issue at play is truly a matter of public concern. And here, the allegations are so vague and conclusory, we don't know if it crosses that threshold.
Well, what does plausible mean?
Plausible means, at least in my mind, more likely than not. It's not quite a preponderance, but, does it pass, I start sounding like we're talking about a pornography case, but does it pass the smell test? You kind of know it if you see it. But here, again, we're dealing with something that is so vague.
That's worrisome, but.
Well, I reach for that simply because of we're talking about something where there is not a clear, bright line that is drawn by the cases, nor is it really possible, given the large variety of circumstances that can
So
come
what's
up.
the underlying principle? You kind of said, does this case deserve to go forward? And that sounds like a pragmatic decision, not a statistical one. And it seems like it depends a lot on context. For example, we're much more lenient, I think, in finding a complaint plausible when the essential facts are known by the defendant, not by the plaintiff. Here we have something that the plaintiff knew, probably knew better than anybody else. Does that factor into whether this is plausible, meaning there's enough here to justify proceeding?
I think that's an
Just
important.
using the word plausible gets me very,
You-
doesn't get me very far.
You draw an important point. I mean, the plaintiff is the master of their own complaint, and here we're dealing with the plaintiff's own speech, which presumably she knew the contents of, the context of it, what was said. She is in a position to provide that information. It is not information necessarily that a defendant would have, because here, if there are allegations of speech in private context, that may not be circumstances where a defendant is aware of those particular contexts or what was said. So is that bare allegation enough to put a defendant on notice of what was said, the topics of the speech, whether it's a matter of public concern? I would submit that it's not.
Well, I think Judge Hartz's question is a good one, and it's something I've been thinking about a little bit. I mean, the point, I think, is to separate those cases which potentially have some merit and from those that are completely hypothetical, conjectural, what have you. Doesn't this complaint, I mean, whether or not the exact language that was used, you get the gist of it. The plaintiff is complaining that she was fired after reporting misconduct in her private capacity. That's a plausible allegation. It seems like we're playing a game of gotcha with these 12b6 motions, that if you don't have enough in there, then we're gonna, you're gonna ask the judge to toss your case. But ultimately, could her complaint have been more thorough? Sure. Is it a paragon of pleading? No. But does it set out a plausible claim for relief?
Again, I would argue that it doesn't. And
Because what?
there is one important gap here in the pleading. The pleading starts out with a discussion of things that the plaintiff observed. And this issue with the line items and the interference. These are things that the complaint says that the plaintiff observed. Then it shifts to what was said. And if you take a look at what was actually stated, there is no connection directly made between the two. There is no allegation that what she said in private or in public context were the same issues identified earlier in the pleading. Now, I guess there's a question whether you can raise an inference, whether she spoke on those things. I would respond that I don't know if that is a reasonable inference based upon what is alleged, and given the fact that, again, the plaintiff is the master of their own complaint. If there was a connection, why was that not stated in the pleading?
Well, again, we can go back to whether it should have been more artfully crafted, yes. But I don't know whether it takes a great leap to look at paragraph 32, which uses exactly the language of allocations, spending allocations, which could encompass both the comment about Giordano's spending money on line items that were beyond policy, or yes, I think that was the allegation in 16, or it could relate to the Convention Bureau. But what we do know is the same language, spending allocations, were raised by her in her private capacity. That's what 32 says. You go back to 16 and 17, I don't think it takes a rocket scientist to connect those two. I mean, so why is that not sufficient?
Again, I don't think that that connection is explicitly made. I think it's inferential. And I would submit that it's not necessarily a reasonable inference.
It is inferential, but inferences are taken in the light most favorable to the plaintiff.
Reasonable inferences, yes.
Okay.
Reasonable inferences, yes. So I'm down to 3 minutes. I want to just briefly, with the court's permission, talk about the issue that the district court decided on the public, whether or not the speech was in connection with the plaintiff's public duties. And here, I think, as Judge Garcia noted, there is some tension between our case and the way the district court handled it here and the Von Busch case that this court recently decided back in December. And in that case, on very similar allegations, the only difference being different plaintiff, different position, and an allegation of termination in Von Busch versus constructive termination in this case, a 3-judge panel of this court found that the plaintiff's petition did not pass muster in the sense that it did not plead speech that was outside of the scope of the former official's public duties. And I think, given that the two complaints closely parallel each other in their substance on this issue, we would disagree with how the district court resolved that issue. Reading the district court judge's order and memorandum, it appears that a lot of the court's concern was, or its rationale was, that she was not being paid for the speech. I am not certain where that finding came from. It is not alleged in the petition anywhere. And in fact, we have the same problem in this case as we did in Von Busch, in that the petition does not, or the complaint does not say what the plaintiff's duties were, what the scope of the duties were, and to demarcate how the speech in question was outside of the scope of those duties. All we have is a conclusory statement.
It does say that she was there in a private individual capacity. It says that she showed up and spoke in that capacity. And what, I mean, you can claim that's conclusory, but it seems to me that when you say you're in a private individual capacity, that's a capacity as opposed to some other capacity, which would be an official capacity. And so she says that throughout. So why isn't that enough?
I think that is conclusory, though. We don't know, again, the context of the speech, the nature of the speech.
How would she do it in a way that's not conclusory? How do you say, I'm speaking in my private capacity in a non-conclusory way?
You know, ultimately, and this gets to an issue that was also addressed in the Von Busch decision.
Wait, are you going to answer my question?
Yes. Is that I think she has to allege on that first prong that also the speech falls outside the scope of her official duties. I mean, she can say all day long that, oh, I'm speaking in my personal capacity, but if it is on the very things that she has official responsibility for, I don't think her own statement to that necessarily merits credit.
If she alleged that, wouldn't we be here with you telling us that that was a conclusory statement, that she spoke outside of her official duties? That is a conclusory statement.
Well, that is, but what I'm saying is that you have to look at the scope of what her duties were. We don't know that information.
Well, we know that she was a county employee. I mean, the first paragraph, I'm an employee of the defendant Board of County Commissioners, and then she later tells us, when I showed up at these meetings, I was speaking in my individual capacity. Doesn't that establish by the virtue of the complaint a juxtaposition between those two?
I do think there's a difference here when you're talking about an employee who's the head of the organization, talking about issues for that organization. And I don't think they can necessarily easily step outside of that role. She was the head of the Convention Business Bureau, talking about matters of import to that organization. I see that I am running out of time. First, are there any other questions from the panel? All right, very good. Well, we would therefore ask that the court affirm the order dismissing the claims against the Board of County Commissioners in all respects. And I appreciate the panel's time. Thank you.
1 minute 15, please. Yes.
Thank you, Your Honors, for allowing rebuttal.
Just wait a second. Okay.
Okay, thank you, Your Honors, for allowing rebuttal. I did want to touch on, well, I want to make 2 main points here, of course, between fielding questions. I would like to bring to the court's attention the the Garcia case, which was attached as an attachment to the brief.
That's district court case, right?
Correct, Your Honor. It is actually the case that Judge Melgren cited. It's in a footnote when he reached what I see as the crux of his decision, where he says that there's not enough detailed information to get to the speech to determine whether or not it touched on a matter of public concern. In Garcia, the Garcia court specifically said that although that complaint did not include the exact specific language, that it did include topics or categories of information in speech.
Although great wisdom does come from district courts.
I was going to say, we're a fan of district
It is a
courts here.
district court. And so I think you might be better served by seeing if you could find a case from this court that would help you.
Yes, Your Honor, and I agree. I think more so I'm pointing out that Garcia does not support Judge Melgren's conclusion there. I would also like to point out, and the judges have already kind of touched on this.
Time is fleeting. Your time
Yes.
is up again, so
She
you better
was-
make your point quick.
Yes, Your Honor, she was at a public monthly meeting in her private individual capacity. She was complaining about the commissioner trying to allocate funds outside of county policy, and then she was constructively discharged.
Thank you, counsel.
Thank you.
Case is submitted.
Thanks for asking.
We're ready for the second case, please. 25-3047, Stoneberger versus BP Energy Company. Please proceed.
Thank you, Your Honor. May it please the court. My name is Sam Mullins on behalf of the plaintiffs in these consolidated cases. I think the broad issue that these cases present is whether the state of Kansas has any authority whatsoever to protect its captive retail natural gas consumers in the face of a declared disaster and a failed natural gas market. The specific issue the district court decided below was that the Natural Gas Act, the Federal Natural Gas Act, preempted the plaintiff's Kansas Consumer Protection Act claims. For 3 reasons, the district court erred, and the plaintiff's Kansas KCPA claims are not preempted. The controlling case is the Supreme Court's decision in One Oak, Inc. versus Learjet, Inc. that controls for 3 reasons. The test under field preemption in the Natural Gas Act context is whether the state law aims at the market, at the FERC jurisdictional market of sales for resale or interstate transportation of natural gas. Here, the KCPA does not specifically aim at that market, like the antitrust.
Whether the statute itself aims at it, or whether the specific action taken under that statute aims at that market?
I think that's a critical distinction, Your Honor, and the answer is, in our view, it is the law. The plain language of the Supreme Court's reasoning in One Oak is what is the target of the law?
So in One Oak, it didn't really have to look at the markets. It could see it was an antitrust case, and that's not targeted at natural gas, so case over. Why did the Supreme Court have to go into all these other considerations?
Well, there are really 2 primary considerations. One is that the antitrust statutes were broad laws of general applicability. They're enacted pursuant to states' historic police power, just like the Kansas Consumer Protection Act is. And that I think the other key in One Oak is that what the court was looking at in particular was a Wisconsin statute, specifically section 133.18, and a Kansas statute section 50-161B. Both of those antitrust statutes allow for claims by plaintiffs, whether they were direct or indirect purchasers. And when the Supreme Court was construing those 2 statutes in One Oak, it didn't draw a distinction in those laws themselves between plaintiffs who were direct purchasers under either 133.18 or 50-161B and those who were direct purchasers.
And that should have ended the case then. They didn't need to decide that they're not seeking any constraints on interstate, that they're focused on retail sales that are local. That was irrelevant to the result in One Oak then. Is that what you're saying?
I wouldn't go so far as saying it was totally irrelevant, Your Honor, because under the facts of One Oak, the plaintiffs alleged, and it was a review of a summary judgment order, that the plaintiffs were all direct purchasers. And the practices at issue affected both state-regulated retail rates and federal-regulated wholesale rates. That fact wasn't necessarily dispositive, isn't dispositive here, because what the plaintiffs are complaining about are state-regulated retail rates and its conduct in connection with those retail rates that are at the heart of the plaintiff's complaint.
Well, your only complaint about the retail rates is that they responded to rates on interstate transactions. Isn't that right?
Well, I think it is correct to an extent, but it's, again, not dispositive because as the Supreme Court acknowledged in One Oak and it also acknowledged in FERC versus EPSA, the retail and the wholesale markets, in One Oak's terms, there's no platonic separation. In EPSA's terms, the markets are not hermetically sealed from one another.
In other words, something that happens in one market can affect the other.
Yes, Your Honor.
And in One Oak, the market that was being targeted was the retail market, and the rates set in that market could affect the rates established for interstate market. Here, what's being targeted are interstate rates, the wholesale rates, and those certainly can affect what the retail rates are going to be. So it's a mirror image of One Oak, is it not?
I disagree, Your Honor, that the wholesale rates are exactly what's being targeted here. And the distinction is the target is what is the target of the law. And the target of the law here is the Consumer Protection Act.
Judge Hart's hit on, well, both of his points are key points, but on the question of what is the target, One Oak specifically says on page 386, quote, "The lawsuits are directed at practices affecting retail rates." The lawsuits, not the law, the lawsuits. And so why doesn't that language support the notion that what we're talking about is the claims, not the law? And again, that would bleed into Judge Hart's second point, which is that really what you're focusing on is how those claims affect retail rates.
I'm sorry.
No, or the reverse, actually, here.
I think 2 points, Your Honor. First, the lawsuits here are directed at retail rates. It is, the Kansas Consumer Protection Act claim is predicated on a consumer transaction. You have to be a consumer. That is a person in Kansas at the end of the supply chain that purchases household goods, enters a consumer transaction. That's a disposition for value in Kansas for property from a supplier. And what matches in the KCPA and the antitrust statutes at issue in Wyandotte is that the definition of supplier includes those suppliers who are engaging in or enforcing consumer transactions, whether or not dealing directly with the consumer. And that matches the statutory language in the Wisconsin statute, section 133.18 and KSA 50-161B. My second point on that, Your Honor, is I think it goes more to whether the Supreme Court's analysis in Kearns versus railroad friction products should apply here.
I thought you said Wyandotte was our guiding star, and if Wyandotte is our guiding star, that language would suggest that we're focusing on claims, and Judge Hart's point about essentially, well, there's always going to be an impact on retail rates, even if you affect wholesale rates. And so the notion being, why in every case where retail rates are as a derivative matter affected, you're saying that there is not preemption?
I think, I'm not saying every case. I think it has to.
This case.
Well, in this case, there are certainly special circumstances in this case. We have a declared disaster, an obviously failed market. Prices had skyrocketed from $2.50 on February 1st to $622 by February 17th. The people that bear the brunt of those prices are retail rate payers. And to get back a little bit.
But the retail rates here are, I think you allege this, are entirely a product of the rates upstream, right?
It is. So it may depend on the distributor, Your Honor, but each distributor, at least if they're the three that are regulated by the KCC, have to pass.
But didn't you allege there was pass-through? The pass-through is in its
Yes.
entirety all the way down to the retail. So the retail rates here are entirely a product of what happened at the wholesale level.
They are in large part the cost of the gas that is acquired at the
In
wholesale
large part
level.
or entirely?
Well, there are other costs that distributors have to account for that can account for the cost of the natural gas that's spread across the consumer base. But in large part, the purchase gas authorization passes the cost of wholesale transactions that the distributors enter onto the retail market.
And why doesn't that create a significant problem for you? I mean, if we're focused on what is the target of the claim and your acknowledgement that really, to the extent that retail rates are affected, which would be perhaps outside the zone of preemption, to the extent that retail rates are affected, they're only affected as a derivative matter because wholesale rates are affected, and wholesale rates from a distributor put you in the zone of preemption, don't they?
No, Your Honor, and if I may, I just want to push back and try one more time at Wyandotte and whether this Wyandotte focuses on the nature of the claim, because it is
Tell me what to do with the
important
language that I quoted to you.
that the lawsuits are what the lawsuits were aimed at. I understand that, but the test that Justice Kennedy set forth was the target at which the state law aims. And what's important in understanding, I think, that phrase is what the court initially said and what the court rejected in the defendant's briefing was this distinction between a Kearns versus railroad friction products analysis and a Stimatze versus Mercury Marine analysis, which I think turns the case in the plaintiff's favor here. And what was the issue was in Kearns is the Locomotive Inspection Act, and Kearns relies on an earlier case that says the LIA admits of no exception to any state regulation whatsoever. That's a far cry from the Savings Clause in the Natural Gas Act. In Section 1B, where the Natural Gas Act, as the Supreme Court has long said, expresses a meticulous regard for the continued exercise of state power. And therefore, it reserves...
Power over retail.
Over production, Your Honor, and retail and local distribution. That's correct. But where that lines up is with the Supreme Court's initial citation in Wyandotte to Stimatze versus Mercury Marine. And what was important about Stimatze, it's a case interpreting the Federal Boat Safety Act. And what that preemption clause does is it barred state laws or regulations, and it didn't say anything about barring state common law actions. And what happened, and so the state common law action in Stimatze was allowed to go forward because Congress didn't expressly or impliedly preempt that state common law action. And what's happening in the savings clause here in section 1B is Congress is reserving to the states authority over retail rates, and that's what is ultimately at the heart of the plaintiff's claims, is these retail rates, in some cases, will take up to a decade to pay back. And so this regulation by claim analysis that the district court accepted under Kearns simply doesn't apply under the Natural Gas Act, which is a statute of cooperative federalism that still allows for states to exercise authority over retail rates. And the Supreme Court, both in One Oak and in EPSA, if I may reiterate, clarified that these markets are not, there's no hermetically sealing between these markets. What happens in one inevitably affects.
Let me put it this way. There's a difference between the target and the affected party. In One Oak, the target was retail rates. They affected wholesale rates. I would think that the target, in your case, would have to be at the level where the mistakes were made. You're not complaining about anything that the retail sellers did, where they had to respond to the wholesale rates. Your complaint is about what happened at the wholesale level. Why isn't that the target, just as the target in One Oak was the retail rates?
It's not the target, Your Honor, because I'd point to the statutory language that we're relying on. The target of the Kansas Consumer Protection Act is the consumer, and it's KSA 50-623B. The whole purpose of the Kansas Consumer Protection Act is protect consumers from suppliers who commit deceptive and unconscionable acts and practices. Consumers, to be protected under the Kansas Consumer Protection Act, you have to be a consumer who entered a consumer transaction.
So the target is the injured party, not the injurer?
Well, the target is the retail rate. And what this is, I think that's what's important under the Natural Gas Act is really, is the state exercising jurisdiction under the sphere of authority that Congress has given it? And so the state here, under the KCPA, is exercising jurisdiction over retail rates. It has defined supplier to include those who engage or enforce consumer transactions, whether directly or indirectly, interacting directly or indirectly. But that's no different than what the Supreme Court held not preemptive, the statutes themselves, the antitrust statutes themselves in One Oak.
Is there any Kansas authority that defines supplier?
The authority I would point to, we've cited Stair versus Gaylord, Your Honor, as a Kansas Supreme Court decision, I believe, from 1981. It applies the KCPA to a supply chain beginning with a manufacturer, Goodyear Tire, to a distributor and a dealer down to the consumer farmer.
And it explains what solicitation, engage, and enforce is?
Well, it explains that the KCPA applies to that supply chain, and it does it by reference specifically to the statutory language. Another case is an unpublished case I'd point to, a Kansas Court of Appeals case called Cole versus Hewlett-Packard, that discusses and describes that Hewlett-Packard in that case was a supplier who manufactured, I believe it was a computer or a printer that was sold to an employer that was then sold to an employee. I see I have 40 seconds left. I'd like to reserve if possible, Your Honor.
Ask you a
Yes, of
question?
course.
I'm sorry.
I'll allow you some time.
So to follow up on Judge Hartz's question, then, if we were to adopt your position, what then prevents clever counsel in the future from using state laws that are of general applicability to circumvent FERC's authority, whether it's Consumer Protection Acts or any other statutory authority that would allow individuals to pursue or damages claims?
Yeah, I think the limiting principles are found in Section 1B of the Natural Gas Act and in the language of One Oak itself. So it has to be a broad law of general applicability. It must be a state law that relies on its historic police powers, the kind of police powers that Congress intended to preserve in the Natural Gas Act after the Supreme Court had invalidated several state regulations under the Dormant Commerce Clause.
All right, thank you.
Thank you.
Good morning, and may it please the court. Beatrice Franklin from Sussman Godfrey on behalf of Macquarie Energy, and today I'll be presenting argument on behalf of all appellees. I'd like to begin with a language from One Oak that Chief Judge Holmes was relying on, the language about looking at the target of what the lawsuits aim at. It comes from a paragraph where the court, in Justice Breyer's opinion, was discussing a parallelism between Northern Natural, Northwest Central, and then the claims in that case. And the court drew a distinction between the regulation at issue in Northern Natural, which was targeted at wholesale, the regulation at issue in Northwest Central, which was targeted at production on the state side of the divide, and then the lawsuits in One Oak, which were targeted at practices affecting retail rates and transactions that took place exclusively in the retail sphere. That language and the rest of the One Oak analysis shows that One Oak does not mean that state laws of general applicability are categorically exempted from a preemption analysis under the Natural Gas Act. If that were the case, the court would not have proceeded to analyze what the actual conduct at issue in that case was. And then the court just a year later in Hughes and EPSA would not have provided a gloss on One Oak that said that the dispositive fact in One Oak was that the conduct there was all on the retail side of the bright line under the Natural Gas Act, and that at most, the lawsuits there had an incidental effect on the wholesale market. Plaintiffs place a lot of emphasis on the idea that maybe there may have been some indirect purchases underlying the facts in the One Oak cases, but that's nowhere on the face of the Supreme Court's opinion. From the very first line, Justice Breyer makes clear that it's a case about direct purchases and practices that occurred in the retail market. The focus of the conspiracy there was on inflating prices in the retail market, and that makes sense because the defendants were defendants that engaged in retail sales. So unlike here, where the defendants have only ever engaged in wholesale sales, at least during the trading that's discussed in Winter Storm Geary, the defendants in One Oak, they were retail sellers, and so the conspiracy was affecting retail rates. Now, if you look at the actual...
If I have a voice, I'd like to ask a question. Excuse me. Your opposing counsel quoted, I believe, another sentence in One Oak that referred to the target of the statute. Explain how you get around that language.
Sure, Your Honor. So, I mean, at a couple points in the opinion, the court talks about, looking at what the statute as a whole intends to do, what are the aims of the statute as a whole. But the court does not say that that's dispositive. The court does not say that just because plaintiffs are bringing suit under a general antitrust statute, that means that the preemption analysis simply doesn't apply. The court says that that is one factor in the analysis, and that's a factor that Judge Crabtree here, in our case, considered. Judge Crabtree gave absolute deference to the fact that the Natural Gas Act does preserve a role for the states. But of course, Judge Crabtree correctly recognized that the Natural Gas Act exists exactly because the states have no traditional authority over the sphere of wholesale transactions. That was the Attleboro gap that the Natural Gas Act was created to fill. So when we are talking about the wholesale sphere, when we're talking about prices and practices that involve interstate sales for resale under the language of the Natural Gas Act, that is an area where there's been no traditional state regulation. And so even if you're looking at a state statute of general applicability, you have to look to see what the plaintiffs are actually asking a court to do, the conduct on which the plaintiffs are actually asking a court to impose liability. Of course, in Mississippi Power, the Supreme Court said that the principle that wholesale rates cannot be attacked by state law. That is a principle that is binding on state and federal courts. It's not just binding on state and federal regulators. It doesn't just apply to state and federal, to state regulations that affect only the natural gas industry. It is a principle that says that plaintiffs cannot come into court and use state law to try and ask for a redetermination of wholesale rates or a redetermination of the validity of wholesale practices that Congress has placed under exclusive federal authority. Plaintiffs in their briefing in here today have tried to reframe this case as one that is involving retail practices and retail rates, but that simply can't be squared with their complaints, which are of course what the court considers on a 12b6 motion. If you look at paragraph 89 of the Mehl complaint, which is at page 180 of the first volume of the appendix, and I'll use Mehl as representative of each of the 5 complaints in this case. Paragraph 89 lists the common legal and factual questions in this case, and those questions all involve questions targeted at wholesale prices and wholesale practices. So for example, whether defendants charged KGS, the distributor there, unconscionable prices. Those are wholesale prices and wholesale transactions. Whether defendants profiteered by charging unconscionable prices to KGS, wholesale prices and wholesale transactions. So again, as Judge Crabtree found, as cases like EPSA and Hughes, which post-date 1 make clear, an incidental or a downstream effect on retail prices is not the relevant scope of the court's analysis. The relevant scope of the court's analysis is what conduct are the plaintiffs actually targeting in this case, and what are plaintiffs actually asking the court to do. Here, the plaintiffs are asking a court to come in and redetermine the validity of rates that are exclusively under FERC's jurisdiction.
Does it matter that there's no ruling by FERC here? They investigated and did nothing. Does that affect the analysis?
No, it doesn't, Your Honor, for a couple of reasons. First, the touchstone of the preemption analysis is congressional intent, and Congress's intent in the Natural Gas Act and subsequent legislation was to create exclusive federal authority over the regulation of wholesale practices and prices. Since the passage of the Natural Gas Act, Congress has determined that the best way to preserve the various interests at play in the national natural gas market is to have a deregulated market. And so what Congress has intended is that market participants will presumptively set the rates for wholesale gas subject to FERC's oversight and authority. So FERC has a variety of tools in its toolkit to address perceived manipulation or other perceived wrongdoing in the wholesale sphere. But what's critical for the purposes of preemption is that Congress intends FERC to be the one with the duty and the authority to oversee wholesale rates. And that makes sense because as the pleadings and the briefing in this case make very clear, as does the case law, the national natural gas market is an interstate market. There are lots of connections between states, transactions, could be on one side of a state line or on another. Interstate pipelines go, all across the country. And wholesale marketers like the defendants here, they are going to be engaging in practices, they're going to be engaging in transactions that can't be subject to a patchwork of liability under different states' laws. That's exactly the opposite of what Congress intended. And furthermore, cases like Transco versus Mississippi from 1986, that illustrates that FERC doesn't need to make some sort of affirmative determination of whether or not a rate is valid for field preemption to apply. What matters is that Congress intended those decisions to happen solely under the FERC umbrella. But to respond to something that plaintiffs' counsel said earlier today, the district court did not hold that there's no ability for Kansas to regulate retail rates. The district court did not hold that there's no recourse for consumers, and the district court did not hold that the KCPA is preempted in every application, certainly, or even in every application to the natural gas market.
Let me talk about the KCPA for a second. In the Kansas cases that you cited, did any of those cases involve a dismissal that focused on defendant's role in the transaction that didn't amount to soliciting, engaging, enforcing consumer transactions? I'm trying to understand what that language actually means and whether that language has been fleshed out in Kansas cases.
So in several of the cases that we cited, so for example, Ellaby and Barry, and then Kastner from this court, they they talk more generally about when an upstream supplier can be held liable under the KCPA. They said that where the defendant did not engage directly with the consumer, whether in terms of the transaction itself, and also in those cases there was no advertisement, no marketing, no solicitation, a KCPA claim wasn't stated. If you look at the cases that plaintiffs rely on, so Cole and Stare, the facts there flesh out what it does mean to solicit or engage in. So in Stare, for example, Goodyear, which was the upstream supplier, Goodyear had made representations to consumers. Goodyear had made warranties to consumers, and Goodyear played a role in enforcing the consumer transaction because it was ultimately responsible through a middleman for the return of the defective product in that case and processing the return. Likewise, in Cole, HP had made advertisements to consumers, and it had marketed its products in a certain way, which makes sense because when you have a consumer good, typically the manufacturer of the consumer good may participate in the marketing and the advertising of the good, even if it's not the one who's actually selling it. Here, the complaints have no allegation whatsoever that defendants solicited, engaged in, or play a role in enforcing consumer transactions. Upstream wholesale marketers, they don't market natural gas to consumers. They don't solicit consumer transactions. The only relationship between defendants and any downstream party in this case are between defendants and their sophisticated commercial counterparties, like these very large gas distributors in Kansas. And the failure of plaintiffs to plead a substantive KCPA complaint mirrors why the claims are preempted. Because plaintiffs are trying to hold upstream suppliers in the wholesale market liable for conduct that takes place far downstream, that takes place in the sale to consumers. And neither the KCPA nor federal law really permits that kind of broad scope of liability. Here, of course—
Let me ask you, it feels like there's this tension in the Supreme Court's decision in 1OK, and it starts out with Justice Breyer saying, the Natural Gas Act was drawn with meticulous regard for the continued exercise of state power, not to handicap or dilute it in any way. That's pretty broad language. And I feel like there's this tension. And so I guess I'm trying to figure out if there is, we're taking the allegations of the complaint as true. So given that, there's no, in your estimation, even with this language that I think you have to agree doesn't, it doesn't set out a bright line test for us. I mean, there's some hedging in there, and it certainly, I read the opinion to preserve the scope of state authority. So how do you square some of that language with the argument you're making here today? I mean, it feels like there are places where if there's price gouging or some other wrongful conduct upstream, that consumers have the right to take action. How do you address that language?
I think that the facts on the ground of what happened here during Winter Storm Geary and afterward, which are included in the complaint, demonstrates exactly the way that state and federal authority can work together in a complementary fashion. So FERC, as I said, has a variety of tools in its toolkit to investigate alleged wrongdoing on the wholesale side. FERC gets extensive market data. They receive huge amounts of financial trading data. They review that, they survey that, they follow up on tips. They did so here. They conducted a number of investigations. That's on the wholesale side. On the retail side, there are state agencies like the Kansas Corporation Commission, which here was also very active in the days and months following Winter Storm Geary. The KCC opened dockets to investigate the retail charges that were passed on by several of the distributors in this case. The KCC held extensive hearings, did extensive fact findings. Consumers were represented during those hearings by a consumer organization. The consumer organization participated in the settlement negotiations and the settlement approval. And the consumer organization was one of the parties that advocated for the settlements that were reached that are described in the complaints because they were in consumers' interest. So that shows that FERC operates on the wholesale side of the divide exactly as Congress intended, and then state regulators can operate on the retail side of the divide exactly as the state, exactly in line with the state preservation of authority under the NGA. What plaintiffs are trying to do here—
Is there any language that says that is always the case, that there's a bright line rule?
Bright line, of course, is a phrase that's used in many of the Supreme Court's other energy precedents. I mean, what One Oak is looking specifically is at the wholesale retail divide and says that where, I agree, as EPSA says, they're not hermetically sealed, but you can look at what the actual target of a lawsuit is, and you can say, is this lawsuit attacking prices and practices on the retail side, or is it attacking prices and practices on the wholesale side? This case is much easier.
Well, it's trying to address wrongs, maybe the practices and the problems are at the wholesale side, but it's the consumers who suffered because of that conduct. And I think it's trying to address that issue, isn't it?
Well, what Congress was trying to do in the Natural Gas Act is to figure out how is the market, including consumers, best going to be served. And what Congress determined was that the best interests of the market, including consumers, if I can finish answering the question, thank you. The best interest of the market, including consumers, is to have a uniform system of natural gas enforcement, and that falls under FERC's authority. One Oak itself says that Congress decided that a deregulated market was in the best interests of everyone, and that determination has to be honored. So what One Oak says is that when you are looking at a lawsuit that really is about retail practices and retail prices, that doesn't interfere with congressional intent because it doesn't cross the line into the interstate sales of wholesale of natural gas for resale. But there's no dispute that that is what plaintiffs are attacking here, and that makes this a much easier case, frankly, than One Oak, because everyone agrees that the crux of plaintiff's complaint is, in fact, wholesale prices and wholesale practices under FERC's exclusive jurisdiction. For those reasons, we think that the district court's thorough opinion is exactly correct, and we respectfully request that the court affirm. Thank you.
Thank you, counsel. If you'd give 1 minute 30.
Thank you, Your Honor. And subject to the court's questions, I hope I can be faster than that. 2 quick points. One, I'd just like to point out on page 24 to 25 of the appellee's answer brief are a list of published Supreme Court cases. What distinguishes every one of those cases from this case is that each of those cases relies on a specific state measure that targets interstate market participation. It's not a broad law of general applicability like the Kansas Consumer Protection Act. And then if I could just briefly follow up, Judge Holmes, on your question on suppliers, it occurred to me one more case to bring to your attention on the necessary connection between suppliers and a consumer transaction. I'd point to Via Christi versus Reed, and the critical statutory language, at least in the non-class action case, is when a consumer is aggrieved by a supplier's conduct, they have a right of action under the KCPA. In the class action context, it's when a consumer suffers a loss as a result of a supplier's conduct, subject to the court's questions.
Thank you.
Nothing further.
Thank you, counsel.
Thank you.
Case is submitted. Thank you for your fine arguments.
No, I can do it.
Okay, I'll defer to you. Whatever you want to do is fine with me. If Judge Houcks wants to push through.
Probably could have made it by the time they clear the courtroom.
Yeah, I know.
That's okay. I'll be.
Okay.
I wasn't sure.
Counsel, I apologize for changing up on you, but we're actually going to go ahead and march forward and hear this next case. And this will be the last case for the morning. The case is 25-3065, Houcks, or I apologize for any mispronunciation, versus Unified Government of Wyandotte County in Kansas. Counsel for Appellant, if you'd make your appearance and proceed, please.
Thank you. Thank you, Your Honor. May it please the court, and obviously your questions are far more important than anything I would try to ram in a rebuttal, but I'd like to reserve about 2 minutes for rebuttal, if that's possible. Your Honors, Quentin Templeton, on behalf of the plaintiffs who were victims of coordinated and repeated rapes, sexual assaults, and kidnappings by the very people who are sworn to serve and protect them, the police and their community.
Mr. Templeton, these allegations are horrific. I accept that. Let me ask, however, as it relates to what is deemed to be, I think in the complaint, one of the principal perpetrators, and I may mispronounce this, but Golubsky, why isn't this case moot as it relates to him? And how do we have jurisdiction over a dead person?
Yes, Your Honor, and this is sort of kind of a tail on the dog here in this particular case, but the substitution issue, and I think it's pronounced Golubsky, but I don't know that it necessarily matters.
Well, there is a substitution issue. I'm aware of that.
Sure.
But it seems to me that right now, as we stand here, we have a dead person in this case. There was no substitution below under 25, and 43 says it permits substitution in a situation unlike this one, because here you had the appellee who died before entry of judgment. So I am scratching my head as to how we have any jurisdiction over him at all.
I think you do have jurisdiction over him, Judge.
On what basis?
The reason for that is if you look at Grand Bouchy, I think is how it's pronounced, this court's opinion from the 90s, where the court said that because the personal representative of the estate wasn't served, then the certificate of death or the notice of death didn't start the clock for the time for substitution.
That's an issue that would be dealt with in the district court. We're not in the district court. That fight should have played out there. We're not fighting that here. We have no authority to do that now. I mean, as it relates to Rule 25, do we?
I think the court does with our motion for substitution, and the reason is our motion for substitution is timely because there hasn't been a clock on exhaustion of it, and
What is the rule predicate for us to act in that regard?
I think, Your Honor, I think this is a factual scenario that isn't contemplated by the rules. The fact that—
We're a rule of law court.
I get it.
I mean,
Sure.
And so, okay, I didn't mean to interrupt. Go
No,
ahead,
no,
please.
no, no. I think it's an important issue.
I thought there was a notice.
There was a notice of death that was filed, but it wasn't properly served on the non-parties to the case, which this court's prior opinion makes clear is a requirement, and in fact, Rule 25 expressly says is a requirement, that it must be served on non-parties pursuant to Rule 4. And the importance of that in this case can't be understated because plaintiffs don't know who the heir or heirs of the estate might be.
Well, why wasn't this argument made below? And let me add on to that, which is to say that what basis did the district court have to enter judgment against Mr. Golubsky? I know it mentioned the fact that there might be a later substitution, but there wasn't a substitution. So, I mean, it seems to me it's sort of jurisdiction 101 that you exercise on the merits when there is a basis for jurisdiction. There wasn't one. So how could the court actually enter judgment against him?
Well, I don't think the
Not
jurisdiction—
against, but
I'm sorry.
not against him, but in favor of him.
Sure. I don't think the existence or non-existence of Golubsky in this particular case changes plaintiffs' rights moving forward against the other defendants. Kansas conspiracy law doesn't require that every conspirator be named in the conspiracy. But to directly answer the question on the substitution issue, the district court didn't address it. And candidly, the district court's opinion, or we were waiting on the district court's opinion for several months until his suicide occurred. And then the district court issued its opinion. No defendant filed any sort of motion or brief to dismiss out that party, and so there was nothing before the court until there was a motion to withdraw filed by Golubski's counsel, and at that time, our notice of appeal had been filed, and the magistrate denied it pending the appeal.
Well, I'm interested to hear your point about essentially your case goes forward irrespective of Golubski. Well, that leads me, however, to the question of your argument about estoppel based upon these alleged threats of the defendants. Well, did you mention any defendant beyond Golubski who made threats against your clients?
Not against all plaintiffs, and we actually have a graphic in our opening brief, Doc 20 at page 29, where we have a graphic sort of drawing some of the lines where some of the contact with various co-conspirators are. But again, going back to Kansas law, each co-conspirator and the threatener of those, or the individual who commits the threats, don't even have to be named under Kansas law.
Oh, all right, you say that, but I mean, but you, in front of us also are motions to certify, right?
Correct.
And where under Kansas law as it stands now, does it say that you have the benefit of co-conspirator attribution for purposes of this estoppel argument that we're talking about, which, as I understand it, is threats were made and until the main perpetrator, anyway, Golubski, was dead, everyone was afraid to come forward. Well, where under Kansas law as it stands now, do you have a predicate for that argument?
Well, we don't have, the complaint actually doesn't limit itself to the threats committed by Roger Golubski. And in fact, we have—
Who else made threats then?
Well, we have two individuals that interacted with two of our plaintiffs. We have another who became the police chief, and then we have—
Please be specific, because I didn't see.
Sure, absolutely.
And interact is not the predicate. The predicate
I
is
agree.
threats.
I agree. We have defendant By and defendant Kill were the two who directly interacted with plaintiff Miller. There's—
They took Miller to see her deceased father, is that right?
correct, and then took her back to—
The threat there, that's pretty standard practice. Maybe it was heartless to do it in that circumstance, but where was there a threat?
I don't think the threat was in taking her to the morgue to see the charred corpse. I think the threat was back at the police station when they spent, I think it was some 20-some hours interrogating her and accusing her of having a sexual relationship with her father, culminating in the sexual assault, and then dumping her off the next day. Now, we don't have with Plaintiff Miller the kind of gun to the head, if you tell anyone I'm going to kill you. But what we do have is, these are not isolated events, and we have sort of in the constellation of probability, we have contemporaneous at the time of indictment and after newspaper reports discussing these acts by Golubski and others, that this is a protection racket being run through the police department in the unified government. We also have other police officers named in the complaint. We have 4 police officers named in the complaint who say either, I tried to come forward and I was demoted or fired, I tried to come forward and I showed up on calls, domestic violence calls without any backup as sort of a sign of don't say anything. We have—
The sorts of examples you're giving there seem to me to diminish your main point, because if there's this internal cover-up, then if someone made an accusation, one of the plaintiffs had made an accusation, they wouldn't worry about it because they knew they didn't need to threaten these people because they knew nothing would come of it. But to get to my concern, I was looking for some allegation that they conspired, that there was a conspiracy to keep the victims from making complaints. And the only actions in that regard that I saw in the complaint were actions by Golubski, nothing showing that he was conspiring with others or that others were even doing parallel things.
We do have allegations against others, and the conspiracy across, sure, the conspiracy across the police department. We have—
You do describe a conspiracy. What I'm referring to is a conspiracy to threaten people. That's the only issue relevant to the statute of limitations concern.
Correct.
Is that there was a conspiracy to prevent the plaintiffs to scare the plaintiffs out of making any allegations for this 20 years or whatever.
Correct. And candidly, Judge Hartz, I think it permeates the complaint. I think it is hard for me, it has taken me a long time to fully appreciate what feels like a different world where our plaintiffs have lived. These aren't isolated incidents. You know, two of our plaintiffs, Sandra Newsom and Nico Quinn, are intertwined in terms of acts that are occurred and have occurred for a long period of time. And then Nico Quinn continues to be stalked by Roger Golubski, yes, but with other overt threats that he's being aided by others in the government. He's being aided by the prosecutors. And if you don't...
You said other overt threats. You're talking about threats by Golubski?
Threats by Golubski that he's working with others in the police department.
I think you're going to ask what I was going to say.
I'm going to elaborate, well, yes, follow up on the point that what your dialogue with Judge Hartz underscores for me, and this is where I see a problem, and then I'm going to move on to a related issue, if I may, which is simply that there's a distinction between, again, this is apparently a horrific number of acts of harm. That harm is alleged to have taken place in the context of a conspiracy. But what really, for the moment, in order for you to act on that harm, we have to get past the limitations issue. And so these allegations that these people are inflicting harm on, you know, the rape, all these sorts of things on the plaintiffs, that doesn't answer the question of why didn't they talk? I mean, you know, granted, different world, but the law requires you, if you're harmed, to do something about it. And so in this context, the only wedge into why they didn't talk is the dead man. And a person who, you, at least by your acknowledgement, could be out of the case and you still go forward. Well, I wonder whether that's true, because you haven't given us anybody else who said expressly, like Golubski, you talk or you're going to pay a consequence, and therefore they don't talk.
And I think that frames the appeal, Chief Judge Holmes, that can co-conspirators benefit from the threats of another conspirator? And Kansas law is crystal clear on this point, that the bad act or the act of one is the act of all under basic Kansas conspiracy
yes,
law.
but that law applies in a context of criminal conspiracies. We're talking about whether you can transpose that law into the context of estoppel here. And as you acknowledge, by virtue of your motion to certify, it's not clear that you can. And that's what leads me into a second point. That leads me into a second point, which is it not the case that you file the motion to certify only in the context of the motion for relief from judgment, not at the time of the motion to dismiss?
We did. And the reason for that is that the district court completely departed from Kansas law. We have the district court citing the Weinstein case from New York, which has been sort of universally rejected, and then the district court inventing estoppel by duress, which is not expressly identified in Kansas law, and then criticizing plaintiffs for not briefing estoppel by duress. And following the district court's order, we said, well, if the district court thinks this is an issue, then let's go to the Kansas Supreme Court and see what they say about it. And the district court denied it.
So you're saying the Kansas law is clear on the question of estoppel by threat? I don't think there are any cases I'm aware of that have decided that estoppel by threat applies.
We don't have a Kansas case of police officers or others threatening to kill people and thereby stopping the statute of limitations.
Or doing any other harm. And so I guess the point I'm getting at is, by virtue of not doing this in the context of the motion to dismiss, that at least brings to mind the legion of cases that we have that say that, you know, when you lose and then file a motion for dismiss, that really puts you behind the
Sure.
blocks in terms of getting one to consider a motion to dismiss.
Sure, and we're not appealing his denial of the motion to certify, and we filed
You're
a separate.
seeking it here, and
We
I'm
sought
saying,
it here
I'm
with this
saying,
court.
why
Correct.
shouldn't you be behind the blocks here?
Well, actually, I am not aware of a case where a party didn't seek certification to the district court and then did to the Court of Appeals after a motion to dismiss order. I'm not aware of that authority, that seeking it to this
If I were
court.
giving you a 28J, which I won't, the reality is there are cases, okay, I'm sorry, I didn't mean to interrupt. Go ahead. You're not aware of what case?
That coming to this court and seeking certification of this court, there's a prerequisite that there is a motion to certify prior to a motion to dismiss. I'm well aware of this court's prior authority that not seeking a motion to certify prior to dismissal, this court has sometimes found that dispositive and refused to acknowledge it, but at other times has nevertheless acknowledged certification.
And I apologize if I misspoke. I wasn't saying it was a prerequisite. I was saying that it could work against you.
Absolutely, and we recognize that.
May I ask one
Of
question?
course.
So let me ask you, I have found Kansas case law that talks about estoppel in the context of duress and suggests that it may be proper. I'd start with, it's a Kansas Supreme Court case. It's 156 Kansas 258. It's an old case, but, you know, it hasn't been overruled, and there have been cases subsequent to that that have cited it, including, I believe, Judge Crabtree in federal court talked about it. If the law surrounding estoppel by duress is unclear at this point, and we don't have any briefing on it, but I think the Kansas courts have said it's a possibility. How do we deal with it here at the appellate level, given it wasn't briefed, those cases weren't discussed, and you're asking for certification about something that seems to me the Supreme Court, the Kansas Supreme Court has already decided. So now here at this level, what do we do with that case law?
Well, I think this court applies that case law. It applies Kansas law as the Kansas Supreme Court has articulated it. And
Now, the problem is it's been distinguished, and there's some suggestion that maybe it only applies in contract cases, and it's not really clear to me, frankly, how to apply it here in this context.
I think that's one of the reasons why the motion for certification is important, or could be important for the court if the court has questions about whether or not it exists. But I also think it's important to frame those cases with Kansas notice pleading requirements, that it is Kansas state court is a notice pleading state, and most of those cases are discussing that estoppel and stopping a statute of limitation is a fact question at summary judgment, not a 12b6 plausibility analysis.
So if estoppel applies, then procedurally, how do you view this case going back to I mean, what does it look like when it goes back to the district court, given your main defendant is Chief Judge Holmes has pointed out is dead? What does that look like then?
If this court reverses and remands all defendants, which I think is proper, if the court did that, then defendants could file a motion, or the estate of the individual, or I guess he actually has an heir that's taken over all of the assets and assigned the estate, could file a proper motion at that time. If this court struck that defendant and said that this court didn't think it had jurisdiction over Golubski at the time of the appeal, and so was striking the defendant and remanding the rest, then we could move forward with the case. And defendants, if they thought there was a missing conspirator that prohibited a statute of limitations defense, could raise it at that time. But there would still be hanging out and waiting in the wings the notwithstanding clause issue.
And then, sorry, I'm pushing it here, I know is
We've got time.
But the statute of limitations, does it begin to run when Golubski's arrested in 2022, when he dies in 2024, or does it matter?
Well, that distinguishing characteristic doesn't matter for our purposes. The Rock Nation Barry Scheck Amici brief articulates that they don't think the statute starts to run until after he's dead. that his existence.
That argument was it in your I mean, that was.
We didn't raise that because we don't need to. It's not a hill we need to die on. We filed, let's see, he committed suicide the morning of jury selection on September 15th, 2022, and we filed November 3rd, 2023. And we allege that the reason why we're waiting in our well-pleaded complaint of, see if I have the number right here for the court, 138 pages, comprehensive complaint, that the reason that they've waited was out of fear. And it's our position that the district court weighed that and made the determination that, as I think the phrase the district court uses is reasonably rely, defendants raise or articulate factually unsupported allegations, which is classic weighing of a well-pleaded complaint. So to directly answer your question, Judge Garcia, the day that the statute starts to run, I think at the earliest is at the date of death, of suicide, and we're clearly timely, assuming the notwithstanding clause issue isn't addressed, we're clearly timely within that. Thank you.
Of course.
Mr. Cooper, we'll be liberal on the time if you need it.
I'm hoping I don't.
Okay.
I'm going to go where you lead me, judges. May it please the court, David R. Cooper on behalf of the Unified Government of Wyandotte County in Kansas City, Kansas, and Chiefs of Police Tom Daly, James Swafford, Ronald Miller, and Terry Ziegler, and Detectives Dennis Ware, Michael Kill, and Clayton By. And for a nitpick, Terry Ziegler was a detective before he was a chief.
And what is your view of the mootness of Officer Golubski, and what's your theory as to why it would be moot as to him?
I raised it in my principal brief that it is moot because they had until March 11th, 2025, in which to file their motion to substitute. They didn't by operation of.
Served properly.
Pardon?
They say the time that you say expired hadn't started because they hadn't been served properly.
Disagree with that. Their clock was running from when I filed the suggestion of death on the record on December 11, 2024. Their argument is the clock never started because somebody else didn't get served. That somebody else was neither a party or a non-party nor a
All
representative.
the plaintiffs were served, is what you're saying.
Correct. The plaintiffs
So their
were
claims
served.
ended.
That's-
Someone who wasn't served might be able to bring a claim.
Yeah. If Matthew Golubski wants to come back now and say, please, I want to be a defendant for my deceased father, the cases they cite would allow him to do that.
A plaintiff for his father.
Pardon?
Oh, I'm sorry, never mind.
Yeah,
I
the deceased person was a defendant in this case. So by operation of Rule 25, they must be dismissed. They had already, Mr. Golubski had already been dismissed by operation of the ruling on the merits on the statute of limitations.
Why does Rule 25 even matter now? Even if
It doesn't.
Even if you fail to do what you did, we're sitting here in the Court of Appeals with a dead man.
I agree with you. There is no way under Rule 43 that there's no mechanism under Rule 43 to substitute. None of the provisions allow it. He was dead before judgment was entered, and he was not a potential appellee. So none of those provisions apply. And so that should be dispositive of the case, but that certainly addresses the motion for substitution. And I guess to be specific so that I'm addressing, and I know that we're making a record as well, under Rule of Appellate Procedure 43, sub A1 doesn't apply because Roger Golubski died before judgment was entered. He died December 2, by the way, of 2024. The suggestion of death was filed December 11. Under A2, Golubski's not a potential appellant, and we're not dealing with a notice of appeal filed by his attorneys, and that's the prerequisite for A2 to have any application. And then A3 doesn't apply, again, because Mr. Golubski died before judgment was ever entered. With respect to the broader claims and the application of the statute of limitations, we do have to get specific about what was the conduct that is alleged in the complaint and when did that conduct occur. My examination or analysis of Kansas law as it applies to equitable estoppel, applying to the statute of limitations, they apply traditional principles of equitable estoppel where there's an act or a representation by in this instance, the defendant that a plaintiff reasonably relies on to refrain from filing their lawsuit. The plaintiff's brief admits they all knew that their rights were violated when the violations occurred. And those violations, according to the complaint, occurred to Ms. Houcks in 1992, to Ms. Newsom in 1994, to Ms. Quinn between 1994 and 2012, to Ms. Williams in 1999, and to Ms. Miller in 2002. And by the way, Ms. Miller has absolutely no contact whatsoever with Mr. Golubski, at least according to the allegations in the complaint.
I'm sorry, Mr. Those dates were when what happened?
The bad acts.
Okay, the bad acts.
And that includes the threats and intimidation alleged in the complaint.
Judge Garcia alluded to Kansas case law that allows estoppel by duress. My question would be twofold. First, is duress the same thing as estoppel by threats? Are they the same thing, one? And two, what is your view of the applicability of that case law as it relates to estoppel by duress?
If it's the case I'm thinking about, no, because that was a contract case, if I'm remembering the one that he's citing, the 159 Can case.
But it dealt with criminal prosecution. I mean, the threat was, we're going to prosecute you if you pursue your claims. I mean, here we have, I mean, you say bad acts. I feel like that's minimizing what happened. Some of these women were raped. They were victimized over the course of years.
Not by any of my clients.
Well,
and that's in
only because of a death. I mean, Mr. Golubski's dead.
True, but again, the statute of limitations analysis will still apply. Was the delay in filing the lawsuit based on the threats alleged reasonable? And I'm looping back to your question, Judge Holmes, which is, I believe the broad language of Kansas law would at least allow for the concept of estoppel by duress or estoppel by intimidation, because the language speaks to, was there an act, a representation, or silence in the face of a duty to speak that the plaintiff then reasonably relied upon to refrain from filing a lawsuit.
So you do think that that case that Judge Garcia is citing could theoretically be applicable?
I think just the general cases that are actually cited in our brief, and I did not cite that one, I know, with respect to, and the quotes that I included in my principal brief say acts, representation, or silence.
Okay, well
and
then.
so we're dealing with acts.
Okay, but then that leads into a second question, which is, whether the other officers, whether Golubski's conduct can be attributed to the other officers under conspiracy attribution. In
That's
other
an
words,
unsettled question.
so you do not believe Kansas law has spoken on that question?
No, I've found no instance where Kansas law has addressed a statute of limitations defense applicable to conspirators who, based upon the acts of an unnamed or unindicted co-conspirator. I looked, didn't find any that fit that category. But what I also, and this is in Judge Krause's decision and it's in our brief as well, which is when you're applying estoppel by duress or estoppel by intimidation, the estoppel period stops at the end of the threats. And the plaintiff's argument is basically by just being alive, Roger Golubski was a threat to these women, whereby from the four corners of the complaint, their last contact with him by any of them was in 2012, 11 years before the complaint was filed.
Well, I mean, if the complaints of Vermis are construed in the light most favorable to the plaintiffs, Golubski was a bad guy, and if Golubski says he's going to kill you if you speak, why? And he appears to still be riding high in the police department. Why would you? I'm not sure it would be irrational to believe he'll come for me if I say something.
First, that's not a reasonable inference to draw from anywhere in the complaint.
Which part is not?
That he's still riding high in 2012 and beyond in the police department. He retired in 2010.
But to Chief Judge Holmes' point, I mean, isn't the only way to find out whether the threat exists is to call him out on it? I mean, you're rolling the dice, aren't you?
No, and it's because, first off, we start with the analysis that Judge Krause actually applied, which is from the four corners of the complaint, can we determine the statute of limitations applies? Was this complaint filed more than 2 years after the causes of action accrued? The plaintiff has conceded those causes of actions all accrued in 2002 or before. So clearly more than 2 years before the November 2023 complaint was filed. Then, from the four corners of the complaint, do the plaintiffs plead themselves into an estoppel situation? And the answer to that is no, because they do not plead a plausible threat by Roger Golubski to anybody beyond 2012. And in fact, Ms. Houcks' last contact was in 1992, Ms. Newsom's was in 1994, Nico Quinn's was in 2012, Ms. Williams was in 1999, and Ms. Miller never met Mr. Golubski, at least from the four corners of the complaint. So there's no way to bootstrap any of those in terms of a plausible threat or intimidation beyond 2012. And the cases that, the JASO case and the Vergara versus Chicago case all speak to, hey, a mere threat or intimidation is not enough to invoke estoppel, period. But even if it were, and these are the Kansas cases that speak to estoppel, it stops with the last act, last threat.
Well, even, let's assume that the threat did linger until Mr. Golubski's death. There would still be an issue, right, of attribution of his conduct to the other
Absolutely.
officers.
Because, and this is detailed beginning on page 11 of my principal brief, but when we're talking about where my clients are mentioned, just mentioned, let alone any allegation of what did they do, the only allegations against Chief Daley are that he was the chief until 1994, and he attended a meeting where Plaintiff Newsom was present. Nothing else. Chief Swofford, there's no allegation of any conduct by Chief Swofford other than he occupied the seat of the chief of police. Ron Millard, same thing. No allegation of any conduct by him other than he served as the chief of police. Dennis Ware, the allegations with respect to him was that he was present when Nico Quinn was presented a photo array regarding the homicide of her, I'm trying to remember if it was cousin or nephew, in April of 1994. Terry Ziegler is alleged, well, he was the lead detective on the homicides by Ms. Newsom's twin sons. And he was alleged to have been Roger Golubski's partner out in the car during 2 occasions that she was with him in 1999.
The occasion she was raped by him.
That's her allegation, is that Mr. Golubski said Ziegler was out in the car. No conduct by or no statement by Ziegler. Michael Kill and Clayton By were alleged to have taken Ms. Miller to the morgue and to have interrogated her for 19 hours, and it's alleged that Michael Kill propositioned her. They described that as a sexual assault. If you want to infer the sexual assault, but there's no threat or no ongoing contact beyond that night. So that's the last contact in 2002. And just putting the bow on it, none of the allegations of the complaint allow the estoppel by duress to tie into any of my clients.
When you threaten somebody, don't talk or I'll kill you, that's going to have an impact on you for some period of time. You say that the cases don't allow that sort of extension of time? Can we, at a reasonable time? Now, maybe the time we're talking about here is not a reasonable length of time, but surely you can't just forget that someone said, I'll kill you if you file a complaint, and then say, okay, I've got 2 years to file the complaint.
I'm smiling because there's no case on point that gets to the answer to your question, Judge Hartz, because all of the cases that describe estoppel by duress basically start from the starting point saying, that's not a thing, but if it was, it wouldn't work here. And so we don't have a case on point that says these threats do apply for the estoppel period.
And they say it wouldn't work here because the threat wasn't strong enough, or?
Or, no, they uniformly say that doesn't work beyond the last act.
And does the case that Judge Garcia mentioned that you didn't cite, does it also have that alternative analysis, or does it just flat out say there is estoppel by duress?
I can't answer your question
Okay.
because I don't recall the
Okay,
details enough.
that's fine.
Who decides the question? Is it a judge question or a jury question?
It's a judge question, Judge.
What
I mean,
are you saying is the judge question?
Are the facts as alleged something that a plaintiff can reasonably rely on to delay, in some instances, 23 years before filing your lawsuit? And the answer to that is it's a question of law, and the answer is no, you can't.
The question of law being that the estoppel stops at the right after the last threat. You say that's a Kansas proposition of law?
Actually, I'm saying two things. One, it's not a thing at all.
Okay.
And two, even if it were, it wouldn't work here because of the delay between the last act and the filing of the lawsuit.
Now I'm confused when you say it's not a thing at all. I thought you conceded that under Kansas law, there could be estoppel by threat.
It's conceptual. There is no Kansas case that says it on four corners that I am aware of in a civil context.
Well, let me just read you 2 lines from this case. Did the threats in the instant case result in depriving appellee of the free exercise of his will? While that is always a question for the jury, the evidence to establish duress must be substantial. And that's from several different paragraphs talking about estoppel by duress.
I remember reading that case. I just can't remember all of it.
About McLaughlin?
Yes.
Okay.
And I guess I'm just trying to figure out the import of that case to the arguments here.
And here, you've got to look to the four corners of the complaint and see what the allegations are, and those allegations are not enough to invoke estoppel.
As to
my clients.
Okay.
And as I understand that's the point. As I understand your argument, you're not, as I understand now, conceding that Kansas law actually blesses estoppel by duress, but you're saying if it does, it doesn't apply here.
That is correct.
Okay.
And my principal brief does say Kansas law does not recognize it in this context, but I also concede and include the quotes that say acts.
Okay.
And bottom line is, I don't think you need to certify any questions. And I will say, I've been the victim of where certification motion didn't happen in the district court. It did at this level, and the motion was granted. So I know it can happen. I just don't think it should, because I don't think this is a hard question for you.
Well, I'm gonna respond to that, because there's so many ways that a case can be decided in the district court. And a state Supreme Court is not going to take certification when the issue could well be mooted by what goes on in district court. So I'm not a fan of saying that if you can't, that if you didn't do it in district court, you shouldn't be allowed to do it in circuit court. I think that's where you should be doing it, but
I don't disagree with you.
maybe in the minority.
I just say certification is not appropriate because it's not a dispositive question. Because even if it was a thing, it's not going to be it's not going to get plaintiff relief in this case.
Understood.
Thank you, Your Honors. You've been very generous with the time.
Case is submitted. What?
I think you promised him a minute.
Oh, did I? I'm sorry. Well, we went 5 minutes, but yes, go ahead, give him a minute.
I know we went way over, so
Well, then I misunderstood.
No, I apologize.
I apologize.
Go ahead and give him a minute, Kevin.
thank you for your grace on that.
No misunderstanding here. Go ahead.
The issue of whether it's a judge question or jury question, it's the plausibility standard. That gets past the judge hurdle. Once we're over plausibility, and this comprehensive complaint more than gets us there. I think what I heard was estoppel by duress does exist in Kansas, and defendants agree to that, but they just don't think it applies to them because there's not a direct threat from them.
I think he hedged. I think he said it's a possibility, but if it does, it doesn't apply.
Sure, hedge is probably more benevolent. But I think that takes us to the certification question then of the overlap between Kansas conspiracy law and Kansas estoppel law, because conspiracy law, and this is Brinkler, which is Kansas Court of Appeals from 2023, it's 538 P3D 1101, an act by any conspirator becomes an act of all, and each is responsible for such act. And if that's good for an element of a claim, it's good for an equitable doctrine under Kansas law. I know I've already expended a massive amount of time with you, so thank you.
No,
Appreciate it.
of course. Case is submitted. Thank you, counsel. Court will be in recess until 9 a.m. tomorrow. Yeah, you can go.
Is this yours or mine? Is this mine?